My name is Colin Tan. I serve as a district judge in the Family Justice Courts. Among the type of work that I do, I hear mental capacity cases in addition to other family law matters. The majority of the MCA cases that come to court are actually applications for appointment of a deputy. We have to consider whether the applicant is an appropriate person to be appointed, then the extent of the powers that this person should be granted. The most important thing that we always have to bear in mind is that the decisions made must be in the patient's best interest. The Mental Capacity Act is a law relating to persons who lack mental capacity to make decisions for themselves. In the event that he or she loses mental capacity in future, the person appointed under the lasting power of attorney, who's called a donee, will have the authority to make decisions for this person. Or if no such document has been executed, then somebody else, most commonly a relative, can apply to court to be appointed as a deputy and to be given the authority to make decisions for this person. The fundamental purpose of the MCA is to protect and safeguard people who lack mental capacity. If we look at a lasting power of attorney, for example, it gives the person the autonomy and the power to choose for himself or herself who is to manage his or her affairs in the event that he or she loses mental capacity in future. If we look at deputyship, for example, where the court appoints someone, then we see that there are safeguards and restrictions that reduce the likelihood of something adverse happening to the patient. Now, of course, some people would feel that the process is very rigorous and that the restrictions are not to their liking. If you look at it from the applicant's point of view, yes, of course, there are forms to fill up. You need to go to court, you need to furnish this information. But if it's looked at from the patient's point of view, then it becomes a different thing. Hey, wait a minute, I don't want just anybody to come forward and take over my stuff. I mean, imagine if a person goes on a round-the-world cruise for 3 months. He comes back and finds that, somebody just happily got an order and has taken over all his property. So there has to be rigor. And I think a person would be willing to accept that when he sees that this also protects him in the event that he loses mental capacity. Every judge loses sleep over every case. Judges care about the cases that come before them. It's important to us to make the right decision. The problem is, of course, that we are limited by the evidence that's placed before us. It's complicated by the fact that the patients who are the focus of the case, whose best interests must be protected, lack the mental capacity to come to court to tell us their position, their view, or tell us what happened. With these limitations, we do have to come to a decision that is fair to the parties, protects the best interests of the patients, and it's not always an easy task, and as a result of which, judges do lose sleep about their cases. I think that the way we cope with it is really having that knowledge that what we're doing is something meaningful, it's something that helps people, and that is a strong motivation that allows us to continue despite the difficulties involved.